So welcome to another one of our webinars. Can I begin by acknowledging the traditional owners of the lands on which we're meeting through the miracles of modern technology. Lemm and I are in Brisbane, and so I acknowledge the Turrbal and the Yagara people as the traditional custodians of the land where we are, but recognise that there are people tuning in from across Queensland. So pay our respects to First Australians, to elders, to ancestors, and to any Aboriginal and Torres Strait Islander people who might be tuning in today. As I was saying to Lemm before, I think this is the third time we've asked him to present to Queensland Community Legal Centres about accessing information, the second webinar and a session at one of our state conferences. And I think the interest that's been displayed by the number of participants shows how important an area this is for us to understand in our practice. Before I hand over to Lemm for what will be another engaging presentation on the topic, some housekeeping things. We're hoping to have a recording of the webinar made available. We'll email a link around to you, assuming the technology works, as well as a copy of Lemm's PowerPoint presentation. There are a couple of ways that you can ask questions as the webinar proceeds. You can type a question into that questions box on your GoToWebinar control panel, or you can press that button that looks like a hand and we can unmute your microphone and you can ask a question either through your computer's microphone or through your telephone, whichever audio system you're using. I think that's the housekeeping type things out of the way. So let me just hand over to Lemm, who, as I said, has provided some great insights to us in the past and will again on accessing information from government. Thank you to Lemm.
Thank you, James, and welcome everybody, and thank you, James, for that wonderful welcome to country as well. Yes, well, good afternoon, everybody. Yes, this is a session on trying to access information from government, and I'll also touch the private sector briefly at the end of it as well. So, yeah, there's quite a lot to go through, and I'll get into it without delay. So, hopefully this next hour will prove to be very useful to you, both in your work, because of course, you know, you might come across this area in the course of your work with clients, but also it's always important to remember that basically all of us have information from government, and all of us on a personal level at some point might want to obtain that information for ourselves. So, of course, the same principles apply whether or not you're acting on behalf of your client or you're acting on behalf of yourself. So, let's get into it. The first thing to remember and the first thing to point out is that, here's the title of it, Accessing Information from Government. That's a bit of a misnomer, actually, because, in fact, you don't actually access information from government. Government's not like Google. It's not like you can ask questions of it. You can't go to it and say, hey, what were you thinking, or what's all that about? Basically, when you access information from government, what you're really accessing is documents. You're accessing government records. Now, you hope that the records that you access, the documents that you access, have actually got the information on it that you're seeking. So you might have a question. What's the story Morning Glory? And what you are going to be calling for is a document which hopefully has information relevant to that question. So yeah, we're not up to the stage yet where you can actually interact as we can with Google here. Now, on the positive side, the definition of document is very, very broadly worded. In fact, it's basically as soon as you have any record, you have a document. So you can access a wide variety of documents. Obviously paper, and stunningly in this age, 2016, government still uses buckets of paper. Whole, you know, Amazon rainforest worth of paper. We still have paper records, we still write paper letters, we still write paper reports. So paper is, you know, not gone away. And it doesn't even have to have paper with you know, the Roman alphabet on it. It could be all sorts of things can be on that paper. And lastly, and this is most importantly, it's also any disc tape or any article, sounds, images, writings, and messages are capable of being produced or reproduced. That's all digital media. So that, of course, is if there is no paper, it's just an electronic record, then you can access it. So that is emails, that is blogs, that is websites, that is social media. That is anything which you can actually then make another copy of it. You can request from government. Now, so what are the sort of things that your clients or even yourselves might want? Well, it's the usual suspects, really. It's, you know, you want information from the hospital or from, you know, a public practitioner. If you've got an issue with child safety, with Department of Communities, if your client is a public servant and they're going through a disciplinary process, obviously police records, massive. Basically, and as I said, you're really looking for documents which actually give you information, documents that say what the hell happened, how did it all happen, why did it even happen. Now, because often people don't know what they're looking for, they end up basically just putting in a sort of kitchen sink thing. Give us everything you got. This doesn't actually work very well. The more focused a request for documents, the better chance you have of obtaining the information that you are seeking. So just bear that in mind. It's very tempting to just go, oh, look, just give us every document you have on this subject. You might end up with like thousands of documents, and virtually none of them are relevant. And as we'll see down the track, there can be a cost to this on several levels. So now, luckily for all of us who are in Queensland, yay, we have one of the more progressive information accessing schemes in the country. We were the first to do what's called the push model. And the push model, which basically says this, is that government will actually hand out information unless there's a good reason not to, with formal applications only being necessary as a last resort. The push model. Instead of sort of saying, oh, please give us something, anything. In theory, government's supposed to just throw as much stuff out at you as possible. And by and large, this came in 2009, by and large, actually, agencies have responded well to this. So there's a thing called administrative access, and which is a very relatively informal mechanism for obtaining a whole heap of information. It is a very simple request. It's called an administrative access scheme. Now, one of the beauties of this is it's very simple, and you get the whole of the document. You get whatever you're looking for. There you go. No clever tricks, no redaction, no arguments about how you can't have it. Basically, you ask for it and they give it to you. And there's a whole lot, and every agency has a whole heap of documents which you can go administratively. Now, this is the Queensland Police Service. Here is some of the examples of information where you can just say, oh, can I have that? And they will just hand you the whole document. And obviously, this is the mechanism by which people do criminal history checks here in Queensland. And it's a very simple process, one-page form. Here it is here, one-page form. All you have to do is prove who you are, put it in, and bang. This is how all criminal history checks are done in Queensland. Relatively informal, called administrative access. Now, the downside of that is there is a cost for this. So the latest fees and charges are this: $55 every time you want to do a criminal history check. Now, often the employer will swing for this if it's in the course of your work. But if you just wanted to, I'm interested, I've forgotten what my criminal history is, it gets complicated after a while, and you want to know, it'll cost you $55 to access that. And then if you want a paper version, there we go, and it's like hundreds of pages long. It's almost $1 a page. So bear that in mind. But there we go, simple method of accessing information. And that's when you ask for it. Agencies also have a scheme where they just basically just publish information, usually through their websites. They're called publication schemes, and they put out buckets of information there on their website through their publication schemes. And so you don't even have to ask for this. You just basically troll through and get this. All agencies must have under the law 7 classes of information, and basically they update it on a regular basis. Again, looking at our friends in the Queensland Police Service, here is their publication scheme. Tiny, tiny little lettering, which just shows the large number of documents that they put out free of charge. Don't even have to ask for them. Just go on the website, just go and access them. About us, our services, our finances, etc. All this stuff is for free. So when you're looking for information, you often can find it just by going onto the agency's website. And one of the things that you can get on this is the good old crimes map. And I put this up every time I do one of these lectures to Quails, because I just think it's wonderful that you can actually get this information. You can get a crime map of your area. This is Stones Corner, where Quails is located. So this is the crimes that happened in August. So there you go. If you're thinking of going out and getting a sandwich during lunchtime, bear in mind that there's a few little areas where crime is a bit of a hot spot. And again, this information is just put out for free. So that's your first port of call, seeing whether or not you can either get it through an admin access scheme or it's already published. For other information, as I said, in 2009 we've got the right to information, or right to apply for documents, which hopefully has the information you're looking for, scheme. And so this is what I'm going to be talking about a large portion of this webinar, the Right to Information Act. And again, the objective of this is consistent with the push model, right of access in the government's possession or under the government's control, unless on balance it's contrary to the public interest to give access, a push model. So there is essentially, you start off with the default position is yes, you can have it, unless there is a good reason not to give it to you. Now there's 2 types of information that is held by government. One is we just call government information, which is information about things, government decisions, etc., etc. The other thing is people's information. Government has a lot of information about people. I mean, Queensland Police Service, Department of Communities, Department of Education, Corrective Services. They've got a lot of information about people, and government information and people's information are treated differently, to the point where they are actually in different acts. So people's information is dealt with under the Information Privacy Act, and that has its own objections: fair collection and handling, privacy. This is what my main job is dealing with privacy. This is where your right to privacy lies, in the Information Privacy Act. And it also is in a different act to provide a right for individuals to access their own personal information. There's parallel schemes. Do you want government information or do you want your own information? And they're treated very differently in 2 different acts. So it's very important to get that distinction sorted out early on. Now, often your information is bundled up with somebody else's information, or it's bundled up with some official information, and it all gets a bit complicated. But, by and large, when they set these acts up, what they thought that would happen is that people would only ask for their information, or they would ask for government information. So if you're formally applying for access, there is a form. Now, that form I showed you before, administrative access, that was 1 page. The prescribed form, which is an official form which has to be used by every single agency in Queensland Government, no choice, no variations, set by Parliament, is painful. But there we go, we are stuck with that form. Only, Parliament can change that form again. So you're looking at that form, you're going, oh, getting a headache. nobody's got any choice in that way. As I said, there's two different types of applications: right to information and information privacy, personal and non-personal. And there's a cost implication for this. For right to information, for government information, there is the odd fee of $43.35. That's just to apply. Even if you don't get anything, the mere act of asking for the information will cost you $43.35. It's a tax for filling out this painful form. There we go. There's also processing charges, but they only kick in when the processing is over 5 hours. And then they can be quite prohibitive. So, you know, these charges can mount up. If it goes over 5 hours, and this is what I'm saying about one of these kitchen sink applications, give me everything, your costs are mounting up. If it goes over 5 hours, you get charged for the 5 hours plus any hours over that at $6.70 per 15 minutes. As soon as you're getting up to sort of 10 hours, you're looking at several $100s there for the processing charges. So discrete, small, focused applications will actually save you money. You've still got the $43.35, and then you've got a photocopying fee at 25 cents a page. And you think, oh, 25 cents a page, that's not very much. But then when you think of it, you've got a ream of paper is 500 pages. If you actually ask for that to be printed out, that's $125 for photocopying. Do not ever do that. If your client comes to you and say, but I can't handle a computer, I can't handle getting it on disk, I can't handle getting it electronically, tell them, no way, Jose. Get them to get you an electronic copy which is free, and then go to Officeworks. Officeworks only charge 4 cents a page. They can print it out there and save themselves a motter of money. All right, that's going on the official version, but there we go. Tough. That's how it works. And then you get access charges. There is no filing fee for applications under the Information Privacy Act. It does not cost you anything to ask for your own information, and that's why that's a very important distinction. You want non-personal information, there's going to be a cost. If you're asking for your own information, it doesn't even matter if it takes 20 hours. There is no application cost, there is no processing charges for those applications. And of course, you've got concession hardholders who are exempt anyway from the charges. So that's always good to bear in mind. Ask if they've got a pension card of some sort, because absolutely that will save them a motter as well. Now, you will get charged access charges even for an information privacy application if you're asking for your own information. And it's essentially these things. If they need somebody, if they need to get it from archives, if they need to actually move it around the country, if it's a audio recording and you want it transcribed, they will charge you for that. If they have to create a document, they will charge you for that. And of course, they still give you the, if you have it in paper, they still charge you the 25 cents per page. These don't come up very often, by and large. People mostly get, you know, that none of these costs come up except in very, very rare cases. So by and large, asking for your own information is relatively painless as far as the dollars go. But don't you love government? Absolutely, everybody loves government. There are different costs. There are administrative costs. Now, obviously, you're asking for your own information. You're filling out this painful form. You're submitting it. They want to know that you're actually you. So there's a whole song and dance you have to go through to actually prove that it's me asking for my information. And that song and dance is you must provide with the application or within 10 business days evidence of identity. And if you, as a community legal centre, are acting for a client in this regard, not only do they have to provide evidence of identity, so do you. Not only do you have to provide evidence of identity, you also have to provide evidence of your authorization to act on their behalf. Now, most evidence of identity, I'll get to the next slide of that, is in itself a bit of a pain, but again, these things are all set in law. So if you want to act for your client in this, you need a client agreement authorizing you to act. That has to be some formal document, essentially, even if it's not anything formal. You need a letter of authorization from your client for you. Now, when you're actually doing evidence of identity, you need a passport, register of birth, driver's license, or a stat dec. Now, these are certified. So the poor person who just wants to get their own file, their own information out of government, has to go to a JP with their driver's license and get that and have a certified copy that, yes, the person in front of me is the owner of this, da-da-da-da-da. That's not so bad for you lawyers, because of course, you can get everybody to certify yourselves, and maybe you can even certify, your client. Nonetheless, if you do not have a certified copy of one of these identity documents, your application will not be processed. These others don't come up. Mainly it's these three: passport, birth certificate, driver's license, or for people who are no docs, and that's, there are members of the community who don't have a lot of these documents. They maybe don't drive, they've never gone overseas, and who knows when their birth was. They need a stat dec from somebody who's known them for at least 1 year. So yeah, this is a bit of a painful process. People are unhappy about this all the time. Lawyers are unhappy about this all the time. In fact, there's a case in QCAT at the moment by a lawyer challenging the need for a separate identity, verified identity, when they've got a authorization on formal letterhead. So we'll see how that goes, but yeah, bit of a pain, but again, no way around it. Now, when you put in an application, the good news is that it's quite a powerful act. Here we go. When you're asking for documents from the government, the IP and RTI Acts, in terms of applications, overrides the provisions of other acts prohibiting the disclosure of information. Basically, they can't say, oh no, our act says no, our act doesn't like it. Tough. The RTI Act actually overrides all other legislations preventing the disclosure of information. Now, catch, of course there's a catch. It's government. They wouldn't be without a catch. The problem is, of course, it overrides everything apart from its own act. And its own act has provisions in which that can be refused. Who needs it from other acts? We've got enough of that in our own act. So you can apply for information, your client can apply for information, doesn't necessarily mean that you get it. When we say right to information, what we say is right to apply for documents with information. That doesn't necessarily mean it's right to obtain documents without containing information. There are a number of exemptions, and this is where the fun part comes in, and this is where you, as community legal centres, can come in, because this actually can be very tricky to negotiate for people who are not used to arguments, bureaucracy, legislative interpretation, or simply just working their way around how all these processes work. There are several ways in which, despite you asking for it, despite you providing the filing fee, despite you filling out the form correctly, despite you putting in a certified copy of your ID, the agency can still refuse to give you the information. There are classes of exempt information. There is this contrary to the public interest test. That doesn't come up very much. This doesn't come up very much. This does. So the three that you will probably come into contact with is that the document is actually exempt from disclosure, from provision. There's a public interest against it. So remember, there's that push test. You should get it unless there's a good reason not to. This is the good reason not to. And this is very common because the document is non-existent or unlocatable. So I'll go through these in turn briefly. So there's a whole class of exempt documents, schedules of them. In fact, there's 3 schedules of these. There's documents to which this Act doesn't apply. That whole 15 categories of documents which you can't even ask for. Mostly they're national security documents, it's bioterrorism and that sort of thing. Sort of documents that you won't come into contact very much in the course of your work anyway. Then you've got 8 agencies who the Act doesn't even apply. They're just like, don't even ask us. The RTI Act doesn't even apply to us. Interestingly enough, I've worked for this crowd, the Office of the Information Commissioner. We're exempt. You cannot actually put in a right to information application to us. We're exempted. We're one of these entities which is exempt from the operation of the Act that we administer. Look, we didn't ask for it. That's just what came with the legislation. So you've got 8 of those. Then you've got certain functions of entities, mainly things like courts, judicial. Anything judicial is going to be exempt. Anything administrative, maybe not so. So it's only certain aspects of their work which is exempt. And then you've got Schedule 3 exempt information. Now you might say to me, hold on a minute, what's the difference between Schedule 1 exempt documents and Schedule 3 exempt information? Oh, the difference between those is exempt information is a subset of documents. So you may get a government report and it might not be one of those which is exempt as a document, but there might be certain sections of it which are exempt within there. Certain parts of a document might be exempt. So this is where you get that redacted, you know, blacked out stuff when you get the document. So these are things, again, look, again, in the course of your work, this is exempt information. Probably for you and your clients, you're not going to get a lot of these unless one of your clients is sort of, you know, wants something which has got a bit more of a high level tone to it. But yeah, so again, if you're asking for any of this information, not necessarily documents, but information, you just won't get this. Interestingly enough, one of these categories, and this comes up a lot, because obviously, as you know, this is of great interest to people, is information subject to legal professional privilege. This is one of those classes of exempt information. Information is exempt information if it would be privileged from production in a legal proceeding on the ground of legal professional privilege. So government's got a lot of lawyers. Any of their communications, just like yours, you cannot actually apply for under right to information or information privacy access. Comes up a lot because people just don't believe it. It's like, no, you know, I can't believe that what you were talking about is actually subject to privilege. So we get a lot of people asking for a review of that. Have never seen one in which it wasn't upheld because the agencies know exactly what legal professional privilege is. So there you go, there's one of the classes of exempt information. Here's some of the entities in which, you know, you can't even get information about. The governor, parliament, yes, they exempt themselves, the parliamentary service, commissions of inquiries. Don't know about P&C associations, why they're left out, but there we go, they're out. Grammar schools, even though we administer them, they're exempt. And yeah, courts, tribunals, government, GOC, some part of government-owned corporations, that's water, gas and electricity. Statutory bodies, that's people like us, the CCC, and yeah, So they're entities in which you can't apply for information. Again, it doesn't come up that often. People know what the score is. They know that they can't get that. In the course of your work, you're probably never going to come across that yourself. Mostly you're going to be dealing with wanting to get information from government about people. And so this is where that public interest balancing test comes in. Now this is an absolute minefield. Or there's my picture of the poor mouse surrounded by too many mouse traps. It's very, very difficult even for seasoned practitioners to negotiate. So I'm not surprised if some clients go to you and they just go, I've got no idea what they were talking about. I've got no idea what they mean. I've got no idea how to argue this. I've got no idea how to get the information that I need to get for this. It can be quite tricky. There's basically 4 categories in the balancing test. Irrelevant factors. Don't even go there. Yep. Don't even cite these factors as a public interest. These things are not public interest. Favouring disclosure? Yay, release the information. Favouring non-disclosure? Boo, don't release the information. And then we've got this special category, super non-disclosure, because there is actually going to be a public interest harm if you released it. So these are the 4 categories in which you balance up when you decide whether or not to say yay or nay to a access application. So let's go over the first ones. Now, I love these. I absolutely adore these. These are just fantastic. Here we go. Disclosure of the information could reasonably be expected to cause embarrassment to the government. This is an irrelevant factor. Irrelevant. Doesn't matter. Can't cite that as a reason for not giving out the document. Disclosure of the information could reasonably be expected to result in the applicant misinterpreting or misunderstanding the document. You can't have it. You're too stupid. No, not a factor. Disclosure of the information could reasonably be expected to result in mischievous. Isn't that a great word? People still use that. Mischievous conduct. They've got a bad motive for seeking this information. Fantastic. Irrelevant. And then the person who created the document is of high seniority within the agency. Now, why I love these is, you look at that and you go, oh, of course. What I love about it is that they had to put this into the legislation. And they had to put this into the legislation because these were factors that people were using to try and deny people access to the information. So good on you, government. You actually put in an act which said, no way, Jose, don't even think of going there with these factors. Again, look, it doesn't come up very much from the agency point of view now. We're 7 years down the track. They know exactly that even if they went even remotely near these areas, they get shot down in flames. So I just think it's lovely it's still there, but yeah, it doesn't come up very much. Now, we're left with the 3 categories. We're left with for, against, and super against. And they can be really confusing because you've got 4. They come in pairs. Disclosure of the information will reasonably be expected to contribute to the protection of the environment. Yep, that makes sense. Disclosure of the information could reasonably be expected to impede the protection of the environment. All right, okay. Reasonably expected to advance the fair treatment of individuals. Yeah, that sounds like a good thing. Disclosure of the information reasonably expected to prejudice the fair treatment of individuals. So you can see here, there's a trend going and it keeps going. There are for and against, and they are diametrically opposed in the 2 schedules. Disclosure of the information could reasonably be expected to contribute to the administration of justice. Well, that's a good thing, absolutely. Could reasonably be expected to impede the administration of justice. All right, sure. Disclosure of the information could reasonably be expected to, including procedural fairness, that's 4. Impede the administration. That seems to be the same. Did I just put the same ones in there? I'll have to check on that anyway. But you can see what I'm going is that basically, as soon as you've got an argument saying, oh yeah, look, we absolutely need to do this for a public interest reason, it's for the administration of justice, there is a counter public interest argument which says, well, actually, no, that will actually go against the administration of justice. Now, you're going to come up against this when somebody is using the counter. Nobody's going to even mention these if they're going, yeah, here's your document, no problem, where are you going? So it's the against ones that you are going to come across. So they're going to say, look, we can't do that, it would hurt the environment. Absolutely hurt the environment, and to let you know how many koalas are being run over on our roads or whatever that it is. And you, well, the poor old applicant has actually got to come up with a counter argument which says, oh, actually, no, this would be good for the environment if we released it. Now, of course, you as lawyers in community legal centres, you're used to making these arguments. You're used to reasoning. You're used to arguing your case. Poor old applicants aren't really as good at that, especially when they've got to not only sort of advance their case, they actually have to basically counter the against case. They come up with things like, I want it. It's good for me to have it. You should give it to me. It's the right thing to do. Well, look, and on the other side, you've got people who are actually making quite reasoned arguments. So this can be quite tricky. It can be quite tricky. But you're helped in some regards by certain principles. This is a public interest factor that is a positive one. It came out from the 1996 case of Wilsford and the Brisbane City Council. And this will come in handy for you and your clients. Basically it says, get out, go away. Basically it says that you're asking for information because you've suffered loss or damage in which a remedy is available under the law. You have a reasonable basis for seeking to produce it. Basically you want to sue, and disclosing the information would assist the applicant to pursue the remedy, or to evaluate whether a remedy is available or worth pursuing. So if you need the information for legal action, even anticipated legal action, there is a public interest in making that information available. This originally one, Wilsford case, came out by some guy who was, I think he was going by on a bicycle. A dog came out from a house, bowled him over, he got injured, he wanted to sue the dog's owner, obviously didn't know who the dog owner was, applied to the Brisbane City Council for the owner of the dog. Brisbane City Council said, no, that's the owner's personal and private information, took it on review, and basically this is where this Wilsford principle came out. Is basically they said, yes, needs it because he needs to be able to sue the owner. There you go. This is followed consistently since 1996. Most recently it was followed in June this year. Somebody had bought a car and they hadn't checked that the seller of the car had no encumbrances on it. And in fact, what happened was that the seller of the car still owed money to a finance company for the car. So the finance company was now pursuing that debt against the new owner. And to do that, they had to apply to the Department of Transport and Main Roads for the contact details of the owner. Now, of course, the new owner was going, not my problem, really, shouldn't be, shouldn't have to be. I just bought a car, I paid full whack for it, now you're telling me that I owe more money. But yeah, that was upheld, that the finance company could get that information so that they could legally pursue a debt. So this Wilsford principle comes up quite a bit that way. Now when it comes to your own information, it gets even more complicated. This is what I'm saying, is that there's costs and benefits to all this. Yes, you don't pay a filing fee. Yes, you're only getting your own information. But it can be quite complicated. It's complicated because, here we go. Here's one of the things. You've applied for the information and it's your information. That's a 4. There we go. Hand it out. Against is disclosure of the information could reasonably be expected to prejudice protection of an individual's right to privacy, which is basically means that you've applied for someone else's information. So you can apply for yours, but as soon as you apply for someone else's, bang, there's an against. If your information is inextricably bound up in theirs, maybe you can't even get yours that way, because it would then disclose the individual's right to privacy. And this is one of those ones where there is one of this new improved against, which is that you actually got a higher burden here if disclosure would disclose personal information of a person, and this is a bit I love, whether living or dead. Like, really, seriously, they're dead. What do they care? Why, why do they care whether or not, any harm at all comes from them? Even their reputation, it doesn't really matter. But there you go. It's in the Act, whether living or dead. Your rights to privacy under this Act continue after you're dead. So, and that is actually even continues if you're a family member. So you've got this four. The information is the personal information of an individual who is deceased, and the applicant is an eligible family member. This is when, the person's died in hospital, you're a close, they died as a victim of crime, you're wanting all the information. There's a four that I'm a family member, I want the information about my deceased person. But then we've got this against, which is interesting. The information is the personal information of the individual, the applicant is an eligible family member, and the disclosure of the information could reasonably be expected to impact on the deceased person's privacy if the deceased person were alive. Now this is fun, isn't it? They're dead, you're the family member trying to get their information, and yet you've got to consider, well, hold on a minute here, if they were alive, would they say yay or nay to this request? You've not only got to put yourself in a deceased person's shoes, but you've got to put yourself in a deceased person's shoes who you don't even know as a decision maker. Now this comes up a bit when it comes to certain health information. For instance, we had one where the person was HIV positive and they did not inform their family at all while they were alive. So when they were going to hospital and getting all this treatment, they weren't telling them what was going on, and all of a sudden they died. And from the family's point of view, they just suddenly died because as far as they knew, that person was not ill. They went to hospital and they died, and that was the first they knew that they even had a medical condition, which of course the hospital wouldn't even tell them about it. And the argument is that, look, if the person wouldn't tell their family while they were alive, why would we tell you now that they are dead because of this against? So sometimes this thing can be a bit tricky. It can be really, really tricky. And as I said, it's a minefield enough for us lawyers, let alone when you come to applicants. Now, generally, there are, as I said, when it comes to government information, you're on a bit stronger ground. And there are a number of accountability and transparency public interest benefits that you should just basically throw into the mix as many times as you can. Weave it into the argument somewhere along the line, because these are actually strong public interest measures, and so don't take advantage of them. There's this one. Reason for a government decision and any background or contextual information that inform that decision. Basically, the decision-making process should be transparent. Weave that in. Open discussion of public affairs and enhance the government's accountability. Absolutely. Throw that into the mix. Contribute to positive and informed debate on important issues or matters of serious interest. So you're going to get the government saying, no, this is sensitive stuff, or yeah, no, I can't tell you about that, ooh, nah. And these are the arguments you're going to bring to bear on this. This is mostly non-personal information. Information to inform the community, the government's operations, policies, guidelines, codes of conduct. So absolutely, these are very, very, very useful arguments when you're trying to get operational information out of government there. So use those all the time. Now, often the information that you are asking for actually started with someone else. It's someone else's information. I mean, government, that happens all the time. In business, you know, you get business proposals, you get tenders, you get communications. You know, we've got that fun at the moment with the Attorney General Brandis not giving his diary out on the people that you're asking for because, you know, oh, it's got other people's information in it. And so there is an onus on the agency to actually consult. Here we go. The agency, only if the agency or minister has taken steps that are reasonably practical to obtain the views of the relevant third party, whether it should be an exempt document, contrary to public information. So they're going to go to the person and say, look, somebody's asked for your information here. Somebody's asked for your tender document. Somebody's asked for you know, your diary notes, and you're mentioned in them. What do you reckon? Now they're going to come back, unless they're actually got, you know, expensive lawyers or are experienced in this field, they're going to come back with an emotive argument. They're going to come back with something along the lines of, oh, yeah, I just don't like them. Absolutely, I'd give it to anyone else, but not that guy. Nah. Or they're going to use that information to just give us hell. They don't want the information. This is just a waste of time and money for us. They're just tying us up in admin. They would selectively use some of the information. They wouldn't understand it anyway. So they're going to put in all these emotive arguments, and this is where that fun thing came with the irrelevant information. Remember those irrelevant factors again? Disclosure of the information could reasonably be expected to result in the applicant misinterpreting or misunderstanding the document. Bam. Or this one, result in mischievous conduct by the applicant. We see this all the time. You give it out to third parties and they just say, we don't trust that they will not use it for a bad purpose. Those are irrelevant arguments. If you see one of those, it's not going to be the government that's going to do that. It's going to be some third party that actually hasn't got experience in this area. So lay down Mazir for you. You can absolutely go, nah, irrelevant factors, guys. Ignore that. If that's the best they can do, give us the documents. Okay, we're coming to the end now. We're doing really well. Well done. Last sections. This is documents which are not available or unlocatable. Again, happens a lot. You ask for a document and they say, no, doesn't exist. Can't find it. Never had it. Never was created. And you go, really? You're kidding me, right? Yeah, you know, you must have this document. Nah. And then they put in an application review. It's called sufficiency of search, which is interesting because what they're really arguing is insufficiency of search. But this whole area is called sufficiency of search. So this is where documents are non-existent or unlocatable. You've asked for it and they just say, no, doesn't exist. So the minister or agency is satisfied the document doesn't exist, or they're satisfied that it should be there, but they just can't find it. And so they can say, no, you're not having it because either it doesn't exist or we just can't find it. And there is actually a provision in the Act that allows this. And look, often people don't believe this. They absolutely don't believe this. They're saying, you're joking, right? This information's got to be there. Well, not necessarily. I mean, people think of public servants as sitting down and just writing everything that happens to them all the day. No, you know, they're like everyone else. You know, they do what they need to do, get by. Often public servants are actually really pushed. They have to do things in short time frames. They haven't got time to do detailed file notes of every single thing in their day. And neither are they required to. Under the Public Records Act, they must make and keep full and accurate records of activities, but only so much that provides evidence of the business or affairs. Now these are, you know, that doesn't mean every post-it note has to be kept. It doesn't mean that every file note, it doesn't mean that every draft, it doesn't mean that every beginnings, scribblings on a whiteboard, you know. Significant documents, absolutely. Documents that provide evidence of business affairs, absolutely they should have them, but it's not every single document. Often they don't keep emails. You know, we had a bit of an email conversation. backwards and forwards, and then we ended up with a final wording for the letter or the document or the report or the decision, and we didn't keep the emails, because the important thing is that report, decision, letter, and absolutely that's been kept. So, you know, I'm not saying that the document doesn't exist. I'm just saying that often people think that there are more documents in government than there actually are. And sometimes the documents do not exist. So there's various reasons for this. They actually, you know, we lose things, we destroy things, we have fires, we have floods. There's that lovely thing in the Yes Minister, you might remember this one, when they had an episode on freedom of information. And, you know, the Minister was going, here are the reasons we can't get this information out. Secret documents, part of active files, some correspondent lost in the floods of 67. Was 1967 a particularly bad winter? And they go, oh, marvellous winter. We lost no end of embarrassing files. Now, we all laughed at that. Oh, what a laugh. Actually, this happens in government too. Strangely enough, we keep a lot of paper. Records departments are usually located in basements. When there are floods, there's one room in the building that's going to flood. It's going to be basement. We actually lost records in the floods of 1973. And, because we've got short memories, we still had documents in basements in the floods of 2011. And, yeah, sometimes, you know, we heard one the other day, a council had lots of documents. They got one of those shipping containers, stuck it in the back of a property somewhere, and we're using that as a storage facility. You know, let's just put boxes of files in there. What they didn't check was whether or not that shipping container was actually watertight. And it wasn't. In fact, what happens was that shipping container was a funnel for storing water, as it turned out. And so every now and again, no fault of anybody's fault, these files are actually destroyed in floods and fires. Sometimes they're lost. They're absolutely lost. It's true, we can't find them. Just like everything. Can't find my car keys. Can't find that odd sock. You know, can't find that present that, you know, I had for my wife's anniversary. Just lost. Never found again. We don't have to keep documents forever. We actually can get rid of documents after a certain amount of time. You think that we keep everything forever? No, we don't. We actually turn over, particularly digital documents. CCTV footage, for instance, is invariably only kept for a month, and then it's overwritten. So if you're looking for, let's have this CCTV of 6 months ago, no, it's been overwritten 6 times since then. Sometimes it never existed, and sometimes it should have existed, but we just didn't get around to doing it. And these things happen. And the trouble is, of course, in any of these cases, we can't make documents up. Essentially, if it is lost, we can't find it, we should have written it, but nobody got around to it, that's it. You're not getting that document. That's just the way it goes. So, having said that, you know, sometimes you get a fresh pair of eyes, somebody looks again, and they can re-find documents. But there comes a point where somebody says, look, absolutely I know you want it, absolutely we might have had it at one point, but we've got no idea anymore where on earth it is. And that's the end of the line for all of that. It exists, but it cannot be found. So, this is government, and I've been talking about government a lot because basically the Right to Information Act, administrative schemes, publication schemes, the Information Privacy Act, these apply to government. They don't apply to the business sector, they don't apply to the community sector, they don't apply for individuals, they don't apply for small firms, sole traders. Essentially, when you're getting information, you're getting information from government. Now, it's not to say that you can't get information from non-government sources. It's not to say you can't actually get a bite of that. You have to go through a different mechanism. Because the Right to Information Act and the Information Privacy Act, the access applications do not apply to non-government, sometimes you have to go through a side door, and that side door is privacy. You've got Information Privacy Principle 6. Now this means an agency must give an individual, the subject of the personal information, access to the document. This is your general right to actually get your own information. Now, not many people use this in government, mainly because you have this. Subsection 2, not required to give an individual under subsection 1 if there is authorised or required under an access law to refuse. And so essentially, if the RTI, the Right to Information and the Information Privacy Application Act applies, Information Privacy Principle 6 doesn't. It defers automatically to the formal processes that way. Now, it's authorised, so if they can say, look, no, we're not going to give you that. I know there's a privacy principle that says you should get it, but we can actually deny access because of one of the reasons in the public interest considerations, then that overrides this right for government. Now, the thing the government's doing at the moment, and it's always done this to a bit, and I've put up this not because of this report, which is a rip of a read. Absolutely have this by your bedside if you're having trouble sleeping. But in this report, which came out just relatively recently, it actually noted that there were 156 non-government agency organisations, NGOs, which were actually providing child services in Queensland. We are outsourcing or contracting out government services, and as part of that, we are outsourcing and contracting out government information, people's information, personnel files, etc., etc. Now, there is this provision in the privacy principles which says when we contract out services to a service provider, the agency must take all reasonable steps to ensure that the contracted service provider is complying with the privacy obligations as if it were the agency. So in other words, the privacy principles will apply to the contractor. Now the RTI Act won't, the Access Application part of the IP Act won't, but the privacy principles will. And one of the privacy principles, of course, is this one. So essentially, if you contract out to a government organisation and you or your clients are trying to get information to a community organisation or even a private sector organisation, and you and your clients are trying to get information out of that, if they are bound to compliance with the privacy principles, and as we saw before, the agency must take all reasonable steps to do that, then this applies to them. This is the first time that a right of access would have applied to these organisations. And it catches them off the hop somewhere along the line because they've got no governance mechanisms in place to actually deal with that. And that's something you have to work through. Sometimes the contracting agency keeps that function, but often you can actually apply. So those 156 organisations providing child services, if you went to them and they were contracted, you can actually get information from them even though the access laws don't apply. So that includes amendment as well. So that's a way of actually getting in, as I said, through the side door, getting a right of access of information from private sector organisations. And I don't know if you've noted, you saw this case, it's under review at the moment, a very interesting case. This is Ben Grubb and Telstra. Ben Grubb was a journalist who basically wanted his own metadata. He wanted his own phone logs from Telstra, and they would not give in to him as a matter of administrative access. So he put in a formal application under the privacy principle. Because Telstra was covered by the privacy principles, they were bound, that right of access applied to them. And this was the reason he could at least apply to Telstra for this information. So it can work in real life if you're trying to get information, but only when They are either covered by the privacy principles or they're contracted to government. In the end, of course, Telstra said no. We understand. That went on review to the Privacy Commissioner, who said, sorry, Telstra, give them the information, and they appealed that decision. So we're waiting to see how that will come out down the track. They basically appealed on the basis that his own phone records was not his own information, because he wasn't identified necessarily from the phone records. So it's a very interesting technical point on that one. So it's something to bear in mind along the way. All right, well, that's it for now. We are the Office of the Information Commissioner. We deal with external reviews of applications. So if you or your client have asked for information, agency says no, sorry, public interest or non-locatable or exempt document or legal professional privilege, you have a right of external review, and this organisation, my organisation, deals with that review, and we make decisions, determinations on those. So that's one of the things we do, is that we can actually say to them, no, give them the documents, or, well, you're quite right, it was actually subject to legal professional privilege. We also do privacy, and that's where I said those access principles could come in handy for you. And generally, we just provide information and assistance to you on anything in this area, including, of course, this webinar that I'm providing to you now. So if you have any queries on this area, if you've got any queries about accessing government information or a contractor information, if you've got any inquiries about privacy, just come to us, and we are a resource for you, for your clients, for the community generally, and we are independent of government, so we will provide information without fear or favour, but basically we provide the same information to everybody. I mean, if I was giving this talk to a government agency, I wouldn't change it in any way whatsoever. The information is the information. We consider the information and the advice we give out is neutral. So absolutely, come to us if you've got any questions, any queries. We are a resource for you and your clients. So thank you very much. Thank you for your patience. Anybody who's still out there, anybody who's still awake, fantastic. I'll see you next year.
Lemm, on behalf of everyone who participated today, can I thank you for that presentation? Can I thank everyone who tuned in? As I said earlier, we will distribute some of the information from this webinar, and look forward to catching up with you soon. Thanks, everyone.
Brilliant. Okay, I'll send you a copy of that presentation, and yeah, enjoy.
Terrific. Bye-bye.
Bye.